Thank you for joining us. I'm Linda Fitzgerald. I'm an advisor with the SBDC, and I am hosting this webinar today for Linda Siniard, the other Linda. And today's topic is hiring and firing first things first. This is the Shasta-Cascade Small Development Center. We are a nonprofit government agency, and we're funded by the Small Business Administration as well as Humboldt State University. This is a confidential, no-cost advisory system. And by that, you've already paid for this with your tax dollars. So we encourage you to reach out to the local Small Business Development Center in your area. We support Shasta and Trinity counties in far northern California. If you're located in the United States, there is a Small Business Development Center in your area. You can go to Google, search for Small Business Development Center and your county name to find an SBDC supporting your area. And I'll start by reading our disclaimer. The information provided in this webinar and any supplementary materials provided to registrants are intended for educational and informational purposes only and does not constitute professional, financial, or legal advice. No registrant should act or fail to act on the basis of any material contained in this webinar without obtaining proper financial, legal, or other professional advice specific to their situation. The Northern California Small Business Development Center and its host, the HSU Sponsored Programs Foundation, specifically disclaims any liability, loss, or risk, personal or otherwise, which is incurred as a consequence, directly or indirectly, of the use and application of any of the information presented in this webinar.
So hello, everyone. I'm an HR advisor for NorCal SBDC. Today, I'm here on behalf of Shasta-Cascade SBDC. I've been in human resources for over 26 years. Before that, I was a legal assistant slash paralegal for about 9 years. I've been an operations manager and a business owner. Down there, you can see credentials, which frankly, very few of my credentials helped all that much in learning employment law and just the everyday minutia of having employees. And there's a lot of it. Okay. So Linda Fitzgerald is going to go through introductions. We want to know who's joining us today. By introductions, are we going to introduce our participants? Linda Fitzgerald.
Yeah. Apparently, Linda's well, she's here, but apparently she's not able to unmute herself. Why don't we go? Go ahead. Yeah, you go ahead.
Okay, thanks, David. I would just like to know who's joining us today. So if you can unmute yourselves or raise your hand and just chime in and let us know who's here.
Go ahead, Mike.
So my name is Mike Filosa. I am owner of a franchise called Chefs for Seniors, where we go bring personal chefs into seniors that are independently living and prepare their meals for them for a week. And I am in the process of just starting to hire some personal chefs, so this is perfect timing.
Terrific. Thanks, Mike. Olga or Genevieve?
Hi, everyone. My name is Olga. I am helping to my husband with his small software startup. And right now there's only 2 of us, but probably we need more people. So hiring and firing is a very important topic for me.
Okay, great. Thank you.
Hi, good morning. My name is Geneva, and my partner and I are hoping to soon open up our company, Above All Food Safety, where we offer food safety training courses and then also proctor the food management exam. And right now, same, it's just the 2 of us, but we're hoping that we can hire some more staff. And yeah, thank you.
Okay,
Thanks.
Great. You should get with Mike. Yeah. Cindy, would you like to introduce yourself?
Cindy, are you muted?
Yep, she's on now.
Okay. Yeah, I think I got it. I got wind and I'm outside, so it might be hard to hear me. I started at Caregiving Decoded. I want to help seniors be able to stay home safely and teach family members to, or neighbors, friends, whatever, to care for loved ones. And so I want to make a course on how to do that. And I take care of a 99-year-old grandfather right now. So as soon as he is gone, I want to start a home care agency and showing people, like, you know, what's important about exercising and meal preparation and keeping them safely at home as long as possible, safely anyway.
Nice.
Oh, terrific. Wow.
And yes,
Thanks.
this is Mike. Cindy and I met on a other webinar last week and have virtually introduced ourselves since we can benefit getting to know each other.
Nice.
Wow, great. There we go.
Okay, so by the end of today, you'll be aware of, I'm not going to say you're going to know all of it, but you will at least have seen the basics of hiring and firing, and then when to contact a consultant or an attorney. It's important to know when you don't know what you're talking about. I have to contact experts all the time. Oh, there's the introductions. Ah, well, we skipped ahead. Okay, the number one thing, and I think one of the biggest roadblocks for a lot of people who are considering hiring their first employee is you actually need a job description. Before you start hiring, you need to know what the job is worth, what's the scope of the job, and find out, do you really need to hire somebody? Lots of times we think we need to hire when what we really need to do is reevaluate the things that we're doing every day. What's worth it and what's not worth it. A job description clarifies for other managers, and you're, in the case of the attendees today, it's going to clarify it for you. These important things. FLSA stands for the Fair Labor Standards Act. It's part of the Department of Labor, so that's federal, and you have to decide if your person is going to be salaried or hourly. When it says exempt and non-exempt, that means, are they exempt from overtime or are they non-exempt for overtime? Talk a little bit more about that in a minute. The essential functions. What are the most important things that you want this person to do? And you want those in a job description, because a job description at a certain point in time can become a legal document that could get subpoenaed. So that's the bad case scenario. The good case scenario is this clarification process. KSAs stands for knowledge, skills, and abilities. You want to know what those things are that are required for the job in terms of knowledge, skills, and abilities, which is different than their qualifications. In a lot of jobs, the qualifications are going to say they have to have a license or a permit or a certification to do a certain thing. In other cases, it may just say things like high school diploma, ability to read, write, and speak English. The physical requirements, and the reason it says with or without accommodation is physical requirements are the things that are necessary for the job. But if you hire someone who's disabled in a particular way, but they have some type of assistive device, then and they can still do the job, that's where with or without accommodation comes in. It's part of the Americans with Disabilities Act. And then a work environment description. A lot of folks think it's not important, but it is. If you have an environment such as a warehouse or a distribution center, and it gets very, very hot in the summer, you need to have that in there so that the person coming in, if they have some kind of heat sensitivity, they can say, oh, that's not the job for me. So the job description also supports performance standards. You can hold people to the standards of the job by saying, hey, you're not really fulfilling this essential function. I'm not sure why that is. Part of the performance review process. And then it also becomes the foundation of your job posting. We'll talk about job posting here. So the worker classification, as I mentioned, Fair Labor Standard Act, exempt or non-exempt, exempt or non-exempt. There's the website. You can look up tons of the exemptions, and those exemptions are listed also right below that. there are actually six now, exemptions to overtime, and they're very, very specific. If you misclassify somebody and pay them as a salaried employee when they actually should have been an hourly employee because they don't have a certain level of responsibility, maybe they're not supervising anyone, maybe they're not a licensed professional, then if someone were to report you, and it's happened to me twice in business environments where the company was reported for misclassification, the Department of Labor, so federal, they can come in and audit all of your payroll records and all of your job descriptions, and they can fine you. That you would have to pay up to 2 years of back pay to the people who were misclassified, meaning all the overtime that they weren't paid. And then if there's evidence that it's a habit or a pattern of the company to misclassify, they'll assess fines and penalties. For the state of California, it's up to the Department of Fair Employment and Housing. California actually will go back 3 years with back pay, fines, and penalties. So the classification, people often say, oh, but they wanted to be paid by salary. They didn't want to punch a time clock. That doesn't matter. What they want doesn't matter. What matters is, are you properly classifying? Next. For those of you who haven't hired your first employee, be really, really careful about the legal requirements around independent contractors. So the IRS has their own set of rules around independent contractors. I think there's 20 different things that they assess to determine if you've hired appropriately for independent contractors. California has some additional ones, and you can find them at the nolo.com website. Just Google nolo.com and then look for California AB5. This actually, AB5 actually was put into place effective January 1st of last year, so 2020. As of this year in January, there are some new exemptions. So all the folks who didn't think they could continue to be independent contractors last year, they've eliminated some of those. So here's an example. If you're a musician and you generally play gigs at a restaurant or a bar or an events venue, of course, none of that happened last year, but in the 2020 version, they were not actually independent contractors. You would have to hire them as an employee if they worked for you over X number of times, and if they worked for you over $600 in that calendar year. So that knocked out a bunch of people, and it was really not pretty. As of January of this year, they have put in some exemptions, and that example is one. So musicians are no longer part of that. The forms that you need for independent contractors are a W-9. That's just like a W-4 that you give a new employee, but it's specific to independent contractors. And then at the end of the year, you're responsible for filling out the 1099. The risks and penalties of misclassifying for independent contractors, very similar to misclassifying for exempt and non-exempt, but even more expensive if you misclassify. You can pay fines and penalties around tax laws, pension and retirement plans, workers' comp laws, and unemployment laws. The other areas where misclassification can exempt independent contractors from rights that an employee would have are the Equal Employment Opportunity, Americans with Disability Act, the Age Discrimination in Employment Act, and the Fair Labor Standards Act. Also, as an employee, you have the rights to leave of absence and reasonable accommodations, which you don't have as an independent contractor. And then wage and hour laws. Wage and hour laws don't apply to independent contractors, but if you've misclassified and they should have been an employee, then you bet they're going to come in and say you owe this person for X number of hours and overtime. Next. Before you actually hire someone, you have to have Form SS4 filled out, turned in to the IRS, and get your employer identification number. And then you also have to establish an account with the Employment Development Department for the state of California so that you are appropriately paying taxes, mandatory payroll taxes. Okay. So workers' compensation insurance is required in California, even if you only have one employee. You have to get workers' comp insurance. For a lot of folks, this is sort of a deciding factor between, do I hire now or do I wait until my revenue stream is healthier? It covers your employees for workplace injuries and illnesses. It also covers you so they don't sue you outside of workers' comp. If a claim is improved, someone gets hurt on the job. I had one of my clients had an employee fall off a ladder yesterday. It was really clear. He legitimately fell. He legitimately hit his head. He went to the hospital. His claim will be approved, and it's going to cover him for time off of work, his medical bills, any prescriptions, and mileage reimbursement when he goes to and from appointments. And then the harsh reality is that some employees who've been hurt on the job or who got sick on the job are going to hire attorneys. They don't feel comfortable navigating the workers' compensation process, and they just want to turn it over to someone who knows it inside out. Payroll systems, if you're going to hire somebody, you're going to have to pay them. Automated payroll systems are going to do the work for you. Calculates the employee and employer taxes, both state and federal. And you don't really have to worry about, was it done right? They're going to know the correct percentages. And I had recently had a client, an SPDC client, ask me, can I do payroll myself? The answer is yes, you can. It's legal. There's nothing wrong with it. But if you make a mistake, then you have to unravel it. And that's where I get the phone calls asking, how do I unravel this? I just overpaid someone, this just happened too, $628 for mileage, and it was supposed to be $12. How do I unravel that? It's quite a process. So I always advise that people get an outsourced payroll service. And if you're a small business, they usually charge you a setup fee plus a per head count fee. So it's not terribly expensive. It's well worth your time to investigate external payroll systems. So here's where you're going to post your open position. You've decided that the job description is necessary. You need this person. The job equals a sell sheet. So this is your job description as the basis of this posting, but it really in the online world or wherever else you're going to market, it's a marketing tool. You can also use employee referrals. If you already have employees, you can ask your employees for referrals for someone they think would be good in the job. And that used to be considered kind of a bad thing to do, like, oh, they're only going to bring in their friends and family. Nowadays, we look at it as would you actually refer somebody to come work here if you didn't trust that they were going to do a good job? No, because it's going to reflect poorly on you. So that's going to change over time. You can also use online job boards like Indeed or ZipRecruiter or LinkedIn. If at a certain point you cross over their threshold of numbers, they're going to charge. LinkedIn is incredibly expensive to do their LinkedIn recruiting portal. ZipRecruiter, not as, Indeed, not as, but you're still going to get charged. Also, if you work in a particular industry, lots of times you have an association that you attend meetings for. Maybe you're a member and you pay dues. Sometimes they have job boards as well. That's a great place to advertise because that's people who are actually in the industry already. And it's far better than using Craigslist. No offense to Craigslist. I used it for years when it first came out and pretty much wiped out newspaper classifieds. But now it's not as specific. You're not going to get what's considered a targeted population of candidates. So with the online job boards, as noted above, Indeed, ZipRecruiter, and LinkedIn, it's the algorithms that they have built into those applications will actually bring up the keywords that are going to be more associated with the job that you're looking for or looking to fill. The other thing is to network with other people in the community. I mean, networking can be anything from friends and family to community associations to the Chamber of Commerce, anything that you're, or small, SPDC as a matter of fact. Mike and Cindy were the two of you that found each other at another meeting. That's networking, and that's sometimes the best place to find people. Next. The application. So a lot of folks think a resume is as good as an application, and I'm here to tell you it's not. An application becomes a legal document if your employee file gets subpoenaed. So you want to make sure that you have the appropriate application for California and for your area. In Shasta County, if you're all Shasta County residents, we do not have any local specific requirements for applications, but other larger cities do. So there's a piece at the end, it's called the applicant attestation. And it's the piece where the the candidate says, everything I've written in this application is true to the best of my knowledge. I attest to its accuracy, and they sign and date. That is the legal component that makes this application something you can use in defense of having hired or not hired somebody. If you hire the person, you keep the application in the employee file. If you don't hire, you can keep the application in job title files for however long you want. You don't have to keep them. It used to be, people used to think that you had to keep it for 6 months or 2 years. Some companies keep them for 2 years because they want to eliminate the expense of recruiting when the job opens up again. So they'll go through the old files thinking, oh, well, they may have gotten a job, but maybe they don't like it, or maybe they've already left. And so they go through the old applications and call people. I've done it for years. This is an add-on to number 7. You have to choose the type of interview you're doing. And this is a little different right now because of COVID. A lot of interviews are done by video conference, and that's great. Some are done by phone. I haven't seen a whole lot of in-person interviews since the pandemic because you don't want to bring them into the office. However, in an essential function job or essential job, excuse me, you're going to bring them in because they would be on site anyway. Then there's a bunch of different types of interviews. There's something called structured, there's behavior-based, situational, panel, stress, and serial. They all have unique formats, and they're very definitely sort of tied to the type or complexity or security of a given job. A panel interview will be like, let's just say you have 4 managers and you want all of them to weigh in. You do a panel interview, you and 4 other managers sitting in a room. The poor applicant is sitting there trying to answer questions from 5 different people now. It can be quite stressful, but it's also very useful in a larger organization environment. A stress interview is meant to create stress. So this is a stress interview is something that happens with firefighters, police officers, oftentimes in mental health facilities. So what you would want to do is just Google, what type of interview do I want to do? Structured, behavior-based, and the list goes on. You'll need to pay attention to Title VII of the Civil Rights Act in order to avoid discrimination in the interviewing process. So you want to avoid any questions that have to do with race, sex, color, national origin, religion. And by the way, the list is extensive now, not just in Title VII, but California has their own list, and we're going to go through that in a little bit. You also need to pay attention to the ADA, that's the Americans with Disabilities Act, ADEA, Age Discrimination and Employment Act, GINA, genetic information, and I can never remember the last 2 letters, and then ban the box. Ban the box is if you have 5 or more employees, you cannot ask about their criminal history on the application or in the interview. If you have made an offer and it comes up that you've done a background check and you can see that they have a criminal history, if it relates to the job, it can be a reason for denying employment, but you have to be very careful about that. Don't do it unless you get legal help. Salary history. This used to be something that was generally asked in interviews. Well, what'd you make at your last job? Well, how about before that? It's now considered discriminatory because what you made at your last job may have been discriminatory in and of itself, in that the company didn't pay fairly. So let's say you're a woman and you got paid $50,000 at your previous job, but this new company you're applying for has actually developed their job description and their pay bands, and they think that the job is worth 75 to 80. So if they ask you your salary history, they're already going, oh, well, maybe we don't have to pay 75 to 80. Let's pay her 55 or 60 and she's going to come on. But that's not accurate, because the salary has to match other people in the same or similar job at your company. Now, if the applicant tells you, well, I made 50,000 at my last job, so I'm hoping to make more now, you know, that's fine, but you're still not supposed to consider salary history. Avoid any questions that have to do with sexual orientation, gender identity, and gender expression. Some of this is more unique to California and a few other states than it is federally. Sex discrimination is discrimination under Title VII, but it gets very specific in California. So gender identity and gender expression are actually different than sexual orientation. If you need more information about that, just Google it. There's tons of information out there. The offer of employment. So for an hourly job, you don't need an offer letter. But if you do an offer letter, let's say you're hiring somebody who's more of a skilled or technician or a professional, and you're going to pay them exempt, so salaried, you need to have in the offer letter the job title, who they're reporting to, the start date, whether they are exempt or non-exempt. You can write an offer letter for a non-exempt employee, whether they're full-time or part-time, temporary, seasonal, and you never write the word permanent in an offer letter. And here's why. There's no such thing as a permanent employee. We call people that we want to stick around, they're not temporary and they're not seasonal, we call them regulars. Their annual salary, what it's going to be on an annual basis. And then the hourly wage, if you're writing an offer letter for an hourly person, so they're non-exempt, you write the hourly wage, let's call it $15 an hour, then you're going to calculate what that would be on an annual basis and put that in the letter, and you need to have their overtime rate. So overtime rate in California is 1.5 times their hourly rate. And that only works if it's over 8 hours a day and over 40 hours a week. And then it goes up when they've worked a 6th day in a row, a 7th day in a row. If they work over 12 hours, again, that's something you would want to get additional help with. The offer letter also has to have the pay days. When do you pay? 1st and the 15th, every other Friday needs to be in the offer letter. What benefits are offered? And then the at-will clause. The at-will clause is the piece that says either the employer or the employee can leave the job at any time without cause. In other words, no explanation needed. That's in 47 states now. And then the easiest thing to do if you're hiring hourly employees is just look up Form 2810.5. It has all the information in it. It's a form letter. It has all the information in it that you need for a non-exempt employee. It also includes your workers' comp carrier. I suggest that if you're hiring hourlies, just use the 2810.5. Don't even bother with the offer letter. Next. New hire forms. W-4, have to have it for federal tax withholding. The DE-4, that's the California version of tax withholding. A lot of companies don't use both, they just use the W-4. You'll want to use both because a lot of folks claim different numbers of dependents on the California than they do the federal, or they may claim exempt on California and not the federal. And then the DE-35 is just a notice to employees, which explains why they have tax withholding forms. The I-9 is the employment eligibility verification. It's part of the United States Customs and Immigration Service. You want to keep this form in a separate file or binder. And there's a reason. If ICE were to come to your place of business, or anybody from the USCIS, and they wanted to see all of your I-9s to prove that your employees were truly eligible to work in the United States, you do not want to give them access to your employee files, just the I-9s. So you keep all your I-9s in a separate file or a binder, separate from employee files. And then you may have company specific forms, like you want an emergency contact form. You may have a non-disclosure agreement or a confidentiality agreement. Benefits enrollments, if you're fortunate enough to be large enough to offer things like group health and vision and dental and life insurance, all those things that cost you a heck of a lot of money, but are big recruiting tools, obviously. You want to have the enrollment forms or help the new hire through the online enrollment process. And then all employers are required by the Employment Development Department to turn in what's called the DE-34, or the Report of New Employees. This came about many years ago when the Department of Family Services was having trouble finding parents who were responsible for child support, and they couldn't find who they worked for. The DE-34 is shared with the county that the person works in of the Family Services Agency that handles child support. So that's what that form is for. Next. Let me just ask, how are we doing on time? Linda,
We're
or
fine.
Dave?
It's 10:39 right now, so we've got
Okay,
a
we're
less
good.
than an hour. Yeah.
Okay, great, thanks. So along with the new hire forms, there are a bunch of required pamphlets for California. This is not true in most other states, but in California, we need to have the disability insurance provisions. There's the list and there's the number from the EDD, the Employment Development Department, that belongs with each one of these. Hang on, DE 2515, DE 2511, and DE 2320, numbers 1, 2, 3, 4, and 5 are all from the EDD. Time to hire is not through the EDD. Oh goodness, what's DWC? David, do you remember?
Department of,
I know. I keep wanting to say Department of Wage Compliance, but that's not it. If you look up DWC 9783.1, you will find it. And then the victims of domestic violence is not a pamphlet, it's actually a notice, it's a printout. It comes from the Labor Commissioner's office, and it basically says that the employer can't discriminate because you are a victim of domestic violence, assault, or stalking. Okay, next. Along with required pamphlets are required notices. So you have to have, even from your first employee, from your very first hire, you have to have posted the federal and state labor law posters. And these can be purchased from a lot of vendors out there. The best price is from Cal Chamber. That's the website to go to their store. They have a ton of employer publications and posters. They have the pamphlets. You can get those pamphlets I mentioned free online. You don't have to have them in pamphlet form. You can just download them from the site, print them, and that covers the requirement. The posters, on the other hand, have to be located where all employees can see them. So generally they're in break rooms or lunchrooms or main hallways. If it's in a distribution center, they're posted next to where people clock in and out, something along those lines. Also, the posters, you can actually download those from the internet. You just have to make sure that it covers all the federal and California labor laws. So you're going to be printing out a whole lot of stuff, and it's kind of a pain in the neck, but you might not want to pay 29 bucks for it. So there you go with the required notices. Employee handbook, safety program, IIPP, I'll explain. Employee handbook, it's not required in California to have an employee handbook. It's not a good idea not to have one. It's considered a best practice. It does need to be updated annually. It needs to cover specifics about your industry. And the easiest way to go about it is to go back to that store.calchamber.com website and look up their employee handbook template. It outlines what employment laws are mandatory, which ones are recommended. You can take them out if they don't apply to your business, and which ones are optional. The optional ones are a lot of best practices, but they may not apply to your business. So it's totally editable. Safety programs. It's not required by law except in certain industries. However, that always runs counter to the fact of the illness and injury prevention plan. I should have spelled that out. Sorry about that. That's the illness and injury prevention plan. Every single employer, you have one or more employees in California, is required to have an IIPP. Used to be it was 10 or more employees. Now it's everybody. And this is it feels, when you're doing it, it feels like, wow, this is really not necessary. I just have somebody working in the office. Why do I need this? Well, because OSHA for the federal government, OSHA for California, says you need it. It's just it's going to tell your employees what you're doing in either the office, the business, retail, restaurant, service industry, whether they're drivers, doesn't matter. It's going to tell the employee how your organization is going to prevent illness and injury in the workplace. And in the IIPP is a lot of safety program material. Again, there's a template. You can look it up at osha.gov. There's one for safety programs and there's one for IIPP. Next. Employee files. So you want to keep a separate file for each employee, and they're confidential. Nobody can look in those files but you, or if you are large enough to have managers, their direct manager. You have to give the employee the right to review it, and if they want copies of it, you have to give them copies of it. That's not true in every state. California is very serious about this because you don't know why the person's asking for copies, and it kind of makes you think, oh no, what did we do wrong? You didn't do anything wrong. Maybe they just need it for their, they're building up their lifetime career files at home. You don't know what they want it for. You can put it in your employee handbook, must give 24 hours notice. And that's because an employee file for somebody who's been there 10 years is pretty thick. So you need time to copy it. You do not keep medical records in an employee file. Medical records fall under a completely different set of rules, and you as an employer are also required to follow HIPAA, just like your doctor's office is. You don't have to have employees sign the waiver or the acknowledgement of HIPAA, but you do have to abide by HIPAA rules and not share medical records. And then the I-9 forms, as I said earlier, you keep them in a separate file or a binder. Benefits. If you're going to offer benefits, then you need to have current documentation. All new hires get the current documentation. And when I say current documentation, when you are fortunate enough to be large enough and profitable enough to offer benefits, you're going to have to sign up for them or renew them every year because the price goes up every year. And sometimes the coverage changes. Sometimes the contracts for healthcare have changed. And so you need to give that to new hires if you offer it. The employee typically pays for part of those benefits through payroll deductions, and you pay the rest. California paid sick leave is a benefit, but it's not like these voluntary benefits like group health welfare. It is required by the state of California that you pay sick leave. And so unfortunately, well, actually, it's fortunate for you if you're in Shasta County. We don't have separate rules about California paid sick leave than the state as a whole. In some cities, they have advanced it so that their employees are eligible for extended sick leave. And during COVID, there is something called extended sick leave, paid sick leave. And so if you need information about the COVID specific extended paid sick leave, that's something you would want to ask me about outside of this meeting. So are there any questions about the hiring piece?
If you have any questions, you can either put them in the chat or just unmute yourself. In the meantime, I can tell you, I looked it up. DWC is Division of Workers' Compensation.
Oh, okay.
You should have known. Yeah.
Oh, so it's, well, DWC is the Department of, but didn't I have it? Did I have it DWC?
You had a DWC that was a form. It was a form.
Okay. Yeah, that's the one.
That's the one, yeah.
Okay, thanks,
Okay,
David.
I think we're fine.
Okay, shall we go?
Yep, let's go.
Okie doke. So then now the not so fun part, when you have to let somebody go. So there's different types of employment termination. Layoff, RIF stands for reduction in force, a business closure, termination for cause, which with the employment development department is known as a discharge, and at will. Another piece, although it's not a termination, but it's often eligible for unemployment claims, is reduced work hours and furloughs, which happened a lot in 2020, and it's probably still happening with some businesses in 2021 due to COVID. So it's not an actual termination. You're just reducing somebody's work hours, or you're going through a furlough program where you're maybe juggling shifts and reducing people to 3 or 4 days rather than full time. There are a lot of different forms of furloughing employees. And then your hope is that those people are going to come back into their prior reduced hours or furloughed schedule to their regular schedule. A layoff. Okay, this is where something's happening in the company or something's happening in the larger geographical area. There's a change, the business is changing direction, they're dropping one of their biggest products because of some supply chain issue, whatever it is. Maybe it's low productivity, maybe it's an economic decline like we just had and are still in for a lot of businesses. Sometimes after a merger and acquisition process, there's massive layoffs. And then other circumstances. These can be temporary or they can be permanent. So you can lay someone off and say, well, when business comes back, you're on the first to hire list or rehire list, or you can lay them off and say, this job is never coming back. This is usually eligible for unemployment insurance. And the why I say use the words typically and usually is that the EDD actually decides if someone is eligible for unemployment. The employer does not. The EDD might have a previous overpayment from one of your employees where they took unemployment while they had started a job. And so they owe back money to the EDD. And there may be other circumstances that you're not aware of as the employer why the unemployment insurance might not get approved. Number 3 is the reduction in force. So this is a larger organizational change that terminates the employment, and this is not a layoff, it terminates the employment of several, in a lot of cases, many employees. It can be a large-scale economic decline like we just had and maybe are still in, within the company, market or industry-based, or geographically. In the case of COVID, it was probably all of those. Within the company, within the local market, within the industry, or also in our case, geographically, meaning the entire country. They're usually considered by unemployment as a layoff. And when you do a RIF, because it's large numbers, you have to keep a list of the demographics. This is their age, the date of hire, their ethnicity, date of termination, all these things that you need to keep in order to avoid discrimination claims. So then also the workers' adjustment and rehabilitation notice is an entire, that's for large companies. You'd have to have 75 or more employees. Most of you are not going to have to worry about that. Business closure, it's pretty simple. If you close your business, termination is going to happen. All your employees are going to be terminated. It's a no-fault claim for unemployment benefits, but again, the EDD decides whether they're eligible. Termination for cause is one of the sticky ones. So it means the employee's done something to violate a company policy, or they're breaking the law at work, or sometimes they've broken the law outside of work and you can't continue to have them work for you. This is particularly important in education, in senior services, and mental health facilities, where people, the consumers of those services, are basically at the mercy of the employees. So if the person, the employee, does something outside of work, like, well, let's just call it assault and battery, you might be able to terminate them because they would be a potential threat to your customers or your consumers. Maybe they just can't do the job. Remember in the job description when I said you need to add the essential functions, maybe the person just can't do the job. And so you're allowed to terminate them. Then there's also a bunch of behaviors or actions that might just not be part of your company's culture. Maybe the person is offensive in some way that is not necessarily discriminatory, not necessarily creating a hostile work environment, but it's not working, and it's in fact may actually be impeding on the success or the productivity of other employees or other managers or you. And so yes, that would be a termination for cause. Have to be careful about it because there's a whole lot of things that people can do that you don't like, but they're not necessarily a termination for cause. So this is a sticky one, and it's the most common reason for terminating somebody. At-will termination. So the sample language, I mentioned this earlier down there at the bottom. Company ABC is an at-will employer. Either the company or the employee may end the employment relationship at any time for any reason with or without notice. Like I said earlier, it's true in 47 states. It can have a lot of long-term effects and legal fees and court costs if someone were to file a claim and say that they had been wrongfully terminated. You may hear that phrase, wrongful termination, a lot in your life. The fact of the matter is there are very few things that can be considered wrongful termination. There typically is some other factor or factors that come into play, and often it's discrimination. Discrimination is one of the most disputed reasons for termination. So be careful when you use the at-will clause that you're not just saying, oh, you know what, I really don't like John Doe, and so I want him out of here. You probably should have a really good, valid reason, a reason that can be documented before you make that decision. Documentation. So in real estate, you've always heard location, location, location. In human resources, you're going to hear us say documentation, documentation, documentation. The costs associated, I just said this, but legal disputes based on discrimination can be astronomical. And I mean that. They can go way, way up. 6 figures is not a stretch at all. And there have been plenty of claims over the years that have been into the millions. They're not infrequent. Actually, if you look up, there's a screen within the Equal Employment Opportunity Commission's website where they post press releases of the largest claims, and they're in all industries. So even if you decide as an employer that you're going to settle with this former employee, it's better to do it sooner rather than later, even if you feel you did nothing wrong. And that doesn't sound like I'm on the side of the employer. I am. And the reason is, as an in-house HR director, I have seen so many companies say, but we didn't do anything wrong. We didn't do anything wrong. And they spend exorbitant amounts of money in legal fees, and then they settle anyway, because no one wants to go to court. Once it's in court, it's public records. Anybody can see it. Carrying along the same thing, performance standards, you want to document those and make sure that they are aligned with your employee handbook and the job description. That's why you update your employee handbook annually, and you update your job description whenever there are significant changes to the person's job. You want to establish a performance management process. That may seem like it's really premature if you're just hiring your new employee or your first employee. The problem is if you don't do it from the very beginning and your very first hire who you thought was so great turns out to not be so great, you want to have documentation about what didn't work. Did they not perform the essential functions? Write it down, keep a list. You also want to deliver the difficult conversations about performance when it happens and directly. You want to help the employee be successful. I will tell you that it is much more expensive to replace an employee than it is to help the employee save their job. It's incumbent on you or the manager of the employee, though, to also offer a plan to help the person figure out what's going to help them improve their job. Sometimes they're completely unaware. Or maybe they just skipped over a piece that in training didn't seem so important, but in the actual doing of the job is very important. And then you want to be consistent about your documentation. You don't want to document just with employees who aren't doing well. Document with the employees who are doing well as well. And again, documentation. It's only as good as the content. So here's some things. These are actual things that have happened in my career in human resources. This was, I still laugh sometimes when I see these. Somebody, a manager wrote, she failed to meet her sales goals because she went out on parental leave. I'm sorry, you can't meet sales goals if you're not at work. So that is actually discriminatory, and it's a sex discrimination thing because only a woman can go out and have a baby. A man who goes out on parental leave, it's also discrimination, not sex discrimination. It's discrimination over their parental status. Another one, she doesn't align with her company culture and it appears to be generational. This was said to me in talking, this was the COO of the company who said this about a woman who was, I don't know, she was probably in her late 50s or something. It appears to be generational. That's age discrimination. Next one, it's unclear why he wants to relocate. And at his age, again, it's age discrimination. Ever since he married that woman from Asia, he seems distracted. Yes, somebody actually said that to me. I have a hard time believing these things when I read them back to myself, but it's an actual documentation fail. These are things that were put in performance evaluations in writing, sent to me as human resources. Of course, I sent them all back and had meetings with these people. And then the one that's the saddest to me, his productivity has fallen off since his daughter died. I don't even know how to, there's nothing to say about that except, are you kidding? It's not a type of discrimination. It's just simply awful. Okay, ooh, my formatting's messed up here. Protected classes. So in terms of discrimination, you want to make sure that if you're terminating somebody, you are not terminating them based on any of these things. So this is the federal piece. So in all 50 states, race, color, national origin, religion, sex, disability, age, citizenship status, and genetic information. That's in all 50 states. Next slide. And then in California, we have additional ones. Ancestry. Wow, I really messed up my formatting here. Marital status, sexual orientation, disability, which is physical and mental. Mental is not included in every state. Gender identity, gender expression, whether the person has AIDS or HIV, medical condition, which does not fall under the Americans with Disabilities Act, because disability has a very specific, distinct definition, whereas a medical condition doesn't actually disable the person where they are unable to fulfill one or more essential functions of life, but it's a medical condition that you may notice, you can't discriminate against it. Political activities, political affiliations, military and veteran status, and then victims of domestic violence, assault, or stalking. I'm not sure why anybody would discriminate a victim of domestic violence, assault, or stalking, but it took a number of years for that to actually be a thing that's protected. So apparently there was a time when the victims were discriminated against. I have a feeling, and I only have one instance in my history that suggests this. We had a woman whose husband had a restraining order, and he had assaulted her, and he began stalking her at work. And so because he began stalking her at work and he had a restraining order and they had this history, there were security pieces to the business that were put in place, and we had to call the police on occasion. So this is a disruption of the business process, of the regular daily business. And for some employees, they felt, you know, insecure that police were showing up at the same time. That employee, she couldn't control that. So, you know, I'm guessing that a history of that is how that came to be an actual required notice and a part of the protected classes. Okay, next. Protected leaves of absence. So you don't want to terminate somebody if they are currently on or recently returned from a leave of absence, or, and I didn't put this in here, but if you know that they're going to go out on a leave of absence. So if they're out sick, and this is including COVID-19 sickness, don't terminate them right away. If there's other reasons for terminating, you wait till they come back and begin doing their job again and keep documenting performance. The Family Medical Leave Act, which often runs concurrently with the California Family Rights Act. If somebody's out on a medical leave or they're taking care of a new baby, you don't want to terminate while they're out on leave or just have returned. Workers' compensation leaves, same thing. And this one is really sketchy because you may have somebody out on workers' comp literally for 5 years, and they're still out there. They're still in your system. And yet terminating them is very, very risky because there are so many components to workers' comp leaves of absence that protect the employee from being discriminated against. Parental leaves, military leaves, and any other type of leave that the person's on. Some leaves of absence are not protected, like sabbaticals for teachers, university teachers. They're not protected. So you could terminate somebody who's on a sabbatical. It would be not a good thing. Certainly it would get around the other, you know, employees' talking points. It would be water cooler conversation, so you don't want to do it, but sometimes there's a reason to. You want to check with an employment consultant or an attorney before you terminate somebody who's on a leave, just returned, or is just about to go out on one. If the person has just made a complaint about something in your place of employment, like sexual harassment, a safety violation, unfair pay practices, anything else that they've complained about, you want to be really careful about terminating them. And the reason is they can think you're terminating them in a retaliatory aspect. It may not be the case. You may have tons of documentation about the poor performance of this person. But the person might actually know that they have poor performance. They might actually feel or gotten wind of the fact that you may be getting ready to terminate them. Maybe they just came back from being suspended for violating some policy that wasn't at the level of immediate termination. And so if they are, you know, complaining about something, address the complaint first. You want to address the complaint. Did harassment, happen? Do your investigation. That's a whole different training, by the way. Are there safety violations that are legitimate? You know, go fix them. If you have unfair pay practices and you're not aware of what they are, but the employee thinks you do, get in touch with a consultant. Okay, if you have any questions about terminating an employee, even in a layoff, do, again, contact an employment professional, an HR consultant, or an attorney. What happens when you contact consultants, I'll talk about myself, is they tell me that my clients tell me what the issue is. I ask a whole lot of questions, because what happens when you tell me what the issue is, there's probably a dozen or more other things that have prompted the phone call or the email that you haven't thought were important to the issue of whether to terminate or not. So if you get on the phone and your attorney or your consultant is asking a ton of questions, it's not meant to be an annoyance or to put you on the spot. It's because most of the time we only see the immediate problem. We don't remember that the whole picture is what needs to be reviewed in order to actually terminate an employee. Then we are going to give you some suggestions. Usually we're going to give you several options. Well, have you tried this, that, and the other thing? We'll come up with some very specific things to the issue that's happening. And then we're going to tell you about the risks of terminating. There's always a risk, even if it's very, very small, when you terminate somebody. Now, not so much in a reduction in force, a business closure, a layoff due to an economic downturn, but definitely there are risks when you terminate somebody for cause, for something that happened, something they did, poor performance, violation of company policy. So you definitely want to get help. If you feel confident about the termination, you've crossed all your T's and dotted all your I's, you feel really good about it, just know that you may be surprised. It happens. Just the most random things can happen. You think it's a good termination and somebody files a claim, and it can be for anything. Again, most often discrimination. Next. These are your termination tasks, and this is not a complete list. Oops, I've got another typo. What the heck was I doing? Final pay rules. Know the final pay rules for state of California. If you terminate someone on the spot, you have to have their final paycheck available and given to them that at the end of that day. In other words, if you terminate them and they leave the property right then, they need to have their final paycheck right then. If the person voluntarily quits, you need to give them their paycheck within 72 hours. You need to have with the termination packet, notice to employee as to change in relationship. It's actually just a form that was supposed to be a parentheses there and not a 9. It's a form, you can find it online. It's called exactly that, notice to employee as to change in relationship. It's something that came up, it's in the labor code for California. It just gives the very specific thing. It's their name, it's their social security number, the date of the end of the relationship, the termination, gives the reason, whether it's a discharge, which means you fired them, whether it's a layoff, reduction in force, whether they quit. And then you want to notify all your benefits providers. If the person has group benefits with you, you've got to tell the providers immediately so they don't charge you the next month for the premiums. You're going to collect all of the equipment, files, cell phone, credit card, whatever this person has in their possession that they may take with them at the end of each day. You know, lots of people take their laptops home, they take their work cell phone, they have a credit card they use every day for your business. So collect everything. You should have a list of that in their employee file. So remember when I said the things you need to have in the employee file? This isn't in there. It's under company specific documents. Then deactivate network access. If this is a person who works on your computers, you want their network access terminated before you sit them down to tell them that they're terminated. Why? Because you don't want them to go back to their desk, get online, and tell the rest of the employees how awful you are for terminating them. So you just want to eliminate that possibility. You want to obtain their passwords to any subscriptions or work in progress that you may have. You want to also notify their manager, or want to have the discussion with them in the termination meeting. What work in progress do you have going on? Because I need to take it on or need to reassign it to, Jane Doe. And then you always want to have a witness in your termination meeting. And that may sound like it's extra sketchy and like, why would I have to have a witness? And the reason is you don't want the terminated employee to leave that meeting, go back to their desk or go home or sit in their car in the parking lot and write down the things that they think you said, and then report that to an employment law attorney on their behalf so that they can file a claim against you. You want to, they may do it anyway, but if you have a witness in the meeting, someone who can say I was there, and they can attest to the fact that you did not say those things, or you did include all the things you're supposed to say, it's the best idea to have a witness. So, any questions now?
No, not really. Is it just for everybody's sake here, is workman's comp insurance required to be in place and effective before the employee is hired? Do you want to do it concurrently or afterwards, or?
Before. It has to be in place before they're actually hired. Because if the person comes to work for you and on day one, they trip over the cable that was underneath the desk that you sat them at, and they get hurt and you're not covered, they can sue you.
Okay.
So you want to
Okay.
have your workers' comp insurance in place before you hire your first person. I have clients who've had their workers' comp insurance in place for several months. Matter of fact, some of them for a lot of months because they planned on hiring last year and then due to COVID couldn't. And so they're still planning on hiring their first employee. And they kept having, you know, they just kept paying their workers' comp insurance because they didn't want to not have it in place when their business was eligible to open up again.
Okay, did you hear that, Mike? Okay. Thank you very much, Linda. Do we have any other questions?
Is there anything in the chat that I can help with?
Not at the moment, but let me go ahead and while people are thinking about it, let
I
me go
have a
ahead.
question.
Okay, go ahead, Cindy.
Okay, if you hire like a bookkeeper or a virtual assistant or something like that, now that would, under the AB5, they wouldn't be hired as an employee, but as an independent contractor. Is that correct?
No. This is the hard part, Sydney. If you hire a bookkeeper, let's use that one as the example. The reason you're hiring a bookkeeper is because they're helping you run your business. So typically that would be an employee. An independent contractor is someone who does not supply something that is standard to running your business. That might be, let's say it would be a typical independent contractor would be a marketing assistant. Marketing is not your business. But in order to promote your business, you may need help with marketing. Maybe you don't know how to do social media marketing, and so you hire somebody to do it. You don't need that person all the time. You just need them on occasion or for special projects. So that would be a real legitimate independent contractor. A virtual assistant. Now, let me just tell you that you're going to hear from friends and family, other businesses. Well, I hired a virtual assistant, and I don't hire them as an employee. That's true because they are actually working through another either staffing agency or they're working online for Upwork or remoter.net. They're working for some other entity that allows them to be an independent contractor. And the reason is that person, let's call it the virtual assistant, has tons of clients. So, okay. They've got tons of clients. They are not just working for you. They use their own tools and equipment. They use their own computer. They're not on your network. They're not supervising any of your people. They're not taking direction from you on everyday activities. You may say, here's the assignment. I need this, that, and the other thing. And they may supply you with, regular everyday things that pertain to your business. In other words, help you run the business. But because of these other factors that I just mentioned, their own tools, they're not taking direction, they work for a bunch of other companies or independent people, they might fall into, now remember, you need to check with the irs.gov on independent contractors, that list of 20 factors, and look up AB5 for California and make sure that you know that this person is a legitimate independent contractor. So yeah, they can be either, but typically a bookkeeper would be somebody in-house. And there's lots of companies that hire external accountants and bookkeepers, but those external accountants and bookkeepers have their own businesses and they do this for lots of clients. Somebody who has their own business is considered a vendor, not an independent contractor. And you hire them to do the work for you because you're not doing your own bookkeeping. I hope that wasn't too much information and just made it more cloudy.
No, it was great. Thank you.
Okay.
This is Mike. I have a question. As part of the interview process, in the demonstration of skills, since I'd be looking for, a personal chef, is it okay, or is there anything I need to be aware of if I have them come into my house or a test kitchen to prepare some meals and observe their skills?
So in that particular instance, no, there's nothing that would prohibit you. It's called pre-employment testing. It actually falls in the category of pre-employment testing, and that can be sketchy. And here's why. If you ask applicant A to come do the, let's call it audition, meal preparation, but you don't ask candidate B to do it because let's just say you've been to their restaurant or you've been to their home and you already are familiar with their cooking, then it's a problem. You have to be consistent. If you're going to ask it of one applicant, you have to ask it of all applicants.
That makes a lot of sense. I understand.
Yeah.
Okay, thank you. Any other questions? While you're thinking about it, I put a link in the chat for a survey. It's a very short survey that we would very much appreciate if you would take the time to fill out. Tell us how you think we did, where we can improve, and feel free to be honest. We have thick skin, and we're looking to get better. So we would appreciate it if you'd fill that out. You will be getting an email from Emily with the slides and a link to the video that we've recorded here and a link to that feedback form as well. And keep in mind, if you'd like to meet with Linda, you can set up an appointment through Emily Christensen, who's our office coordinator here. She basically runs the place, and her email address is emily@norcalsbdc.org, and I believe we'll have a slide up with her information here shortly.
So just to recap here, if you don't feel like you have exactly every single thing that's going to make you feel confident to hire or fire, you've at least become aware of your best course of action. And when you receive a copy of these slides, you're going to have some, the bullet points that tell you the things you need to pay attention for. You can Google all of this stuff. I've been Googling it ever since Google came out. And I've been doing this for 26 years, and I've been through an enormous amount of education to be able to handle this for companies and for clients. But when you first start out, it can be a bit overwhelming. Just do your research, do your homework, and then if you need help, certainly get in touch with Emily, and she'll refer you to me or another HR advisor for SPDC. If you're a client of SPDC, that's the email address I use for specific to SPDC. If you're not a client, I don't know if anybody that participated today was not a client. If you're not a client of SPDC, that's the email I use for my other clients, people who are outside of SPDC. And my phone number always stays the same. Feel free to text me or call me. Thanks everyone for participating. I appreciate your time. I know it was a lot of information to try and cram into what, an hour and 20 minutes or whatever. If there's anything that comes up for you later, again, just get in touch with Emily.
And I'm putting Emily's information in the chat. If you are not in Shasta or Trinity County in California, there is an SPDC near you. There's almost 1,000 of them nationwide. We cover every county in the nation. You can Google SPDC and find out where the closest one is to you. If you're in Shasta or Trinity counties, please contact us if you'd like more information. And I'm going to put in our website as well. There's our website, spdcsc.org. and you can sign up for our services there. They're completely free of charge. You've all paid your taxes, and that's what pays us. We're funded by the Small Business Administration in the state of California. So our services, just like these webinars, are all free of charge to you. There. What am I forgetting, Linda?
Well, the key thing is for people to fill out their survey, because we are making presentations, webinars better every time because of their honest feedback. So we love to hear what they have to share with us. And Linda Siniard has such valuable information. So know that you have access to Linda if you're in Shasta or Trinity counties, or someone like her if you're in another county in the US, because the SPDC, you have paid for the services already with your tax dollars. And if you're a business and you need some support, we want you to know you're not alone.